Hello, everyone, and welcome to SCORE Fairfield County's live webinar on intellectual property basics for businesses. I'm Bob Hogan, the webinar coordinator and a business mentor here at SCORE Fairfield County. I'm going to be your host today, and our presenter is Harvey Hoffman. More on Harvey in just a minute, but first some brief information on SCORE. If I could ask you to move the slide, please, Harvey. SCORE is a nonprofit national partner of the SPA, and locally here at SCORE Fairfield County, we have over 100 volunteers with a wide range of industry, process, and subject matter expertise. And we offer three primary value-added services to small business owners. First of all, we offer free one-on-one individual counseling, and you can access that by face-to-face, video, telephone, or email. And you can do that by clicking on the yellow bit.ly link that you see on the screen, or you can go to our website and click on Request a Mentor. Secondly, we offer a wide range of educational workshops and webinars like the one today, roughly 100 throughout the year. And lastly, we offer extensive resources on our website, including access to subject matter experts. Our next live webinar will be this Friday, December the 17th at noon, and the topic is Aligning Purpose with Profit with Emily Reasoner presenting. And you can find, again, more details on our website, fairfieldcounty.score.org. If you're on our website, we also offer a large number of archived webinars on a wide range of business topics that you can view at any time on demand. Just some logistics about today's webinar. We have set a time for Q&A at the end of the presentation, but if you have a question, you can ask it at any time by typing it in via the Q&A button, which is at the bottom of your screen. If you hover on the bottom of your screen, you'll see a Q&A button, and you can just type your question in there. Our webinar will end sharply at 1 o'clock to respect your time. The session is being recorded, and the link to the recording will be available on our website, fairfieldcounty.score, within the next couple of days. It's now my pleasure to introduce our speaker, Harvey Hoffman. Dr. Hoffman has held positions in industry ranging from research and development engineer, group manager, project manager, to general manager. In aerospace, he worked on the space shuttle and the Titan rocket. He also holds a patent for a digital scan converter employing an accelerated scan. Harvey is the author of project management and capstone project books and more than 20 academic and technical papers. He currently teaches business courses at Fairfield University. I'll now turn it over to Harvey. Harvey, it's all yours. Harvey, I think you're on mute. Harvey, could I ask you to unmute? Harvey, you're still on mute, Harvey.
Okay.
There we go.
Okay, sorry about that. I'd like to begin by thanking everybody for coming and attending this. I want to make it clear that although I'm talking about intellectual property, I'm not an attorney, I'm not a patent agent. And the material, and I have a cold, so I apologize for that. So the material is provided for your guidance, but if you want the minute guidance and information, then I suggest that you speak with an attorney. So let's talk about intellectual property. Well, I'm going to be mentioning things about patents, copyrights, trademarks, registered designs, and trade secrets. And patents are the most common thing that most people think about. I'll talk a little bit about that. New inventions, copyrights, I'll talk a little bit about. And let's begin with the copyright, the concept of copyright. You know, the copyright is discussed in the US Constitution. In the Constitution, we talk about the fact that the Congress shall have the power to promote the progress of science and useful arts by securing rights for authors and inventors. Isn't that interesting? So, can obtain protection? What can be covered? I'll try to answer some of these questions. Anything that you write down is copyrighted automatically. It's got to be tangible. It's got to be things like a literary work, a musical, a book, written material, perhaps motion pictures, video, images, paintings. All of this is copyrightable. If you own the copyright, you have the exclusive right to reproduce it, to distribute copies, and perform an act or to display the information. In general, US work that you copyright is protected in other countries if that country has entered into an international agreement. Now, this is only to do with copyright. I'll talk more about patents later. My patents are different. Okay, so it really depends on the laws of that country. The protection is valid, as you can see here, for the life of the author plus 70 years. For a corporation, it's 95 years from the date of publication or 120 years from the date of creation. Date of publication and date of creation, of course, can be significantly different. You can go to the Copyright Office right over here if you want to, and you can copyright something officially. And you can go there, you go to this website, and you can do it official. So what's the advantage of doing something officially, the government's patent office? Well, if you do it officially, you can sue someone using your work. If you don't do it officially, you can't sue somebody. So that's basically the difference. So you can do that. You can't copyright ideas, procedures, processes, methods of doing things, concepts, or discoveries. We'll talk about discoveries in terms of patents. So there are times when, even though you're the author, you don't own the copyright. I've written a book or two, and I don't own the copyright on those books. My publisher owns it. So even though you're an author, doesn't mean that you're necessarily the owner of the copyright. It's a good idea if you want to put down on the piece of paper, on the document, that it's copyrighted. It's not absolutely required, because anything you put down on a piece of paper is indeed copyrighted. So it's yours. And this is the way, this is the format that you might want to use to demonstrate that something is copyrighted. So if you want, you can take some software and you might be able to copyright that. That's fine. You can copyright it individually, or you can copyright it together with someone else. Okay, so if you want, you copyright it, and then you have use of it. Now, there are times as an academic, I can go ahead and make use of something that is indeed copyrighted, but I can use it as an example. If I take a piece of the work and show it in a lecture, then that's permitted. That's not an infringement. So if I take the entire work, that's an infringement. But if I take a piece of the work, it's not an infringement. So let's talk about a patent. A patent is one of the types of intellectual property. I mentioned I'm going to talk about, I've already talked about copyrights. I'll talk a little bit about trademarks and secrets. But let's talk a little bit about patents. A patent is protection for an invention, and it permits you to make, to manufacture, to use or sell an invention for up to 20 years. It's an official notice to the public. Now, keep in mind that when I patent something, it applies only within the country that I'm patenting it. So if I patent something in the United States, it's only good in the United States. There is a way, I'll talk about it in a moment or two, to patent something elsewhere. But basically, most of us will patent something in the United States, and it's only good that patent is only good in the United States. So a patent is going to permit you to make something, and it protects you only in the country where the patent was granted. It permits you, the patent permits you to sell the rights, and it's good for 20 years. What's interesting is the patent doesn't grant you the right to use your own invention. I'm going to show you now in a slide in a moment. I'm just running down here. I'm looking for a slide, which I can't find. Here. Then I'll go back. Here's a pencil. Everybody's familiar with a pencil. Dick patented this pencil. Jane patented an eraser. So my question to you is, who can manufacture the pencil and the eraser? Interesting question. Two different people. Well, it turns out neither one of them individually can manufacture the pencil with the eraser. They have to get together because each of them has a separate patent. So just because you've patented something doesn't mean that you can manufacture it. You have to be careful that you're not violating another patent. So I'm going to run back here. That's what I mean over here when I say the patent doesn't grant you the right to use the invention, even though you have this patent. Now listen, if you have an idea for a patent, you have an invention, don't publish anything about it. You cannot sell. You can't sell that product, or you can't lecture about it. You can use a non-disclosure agreement to talk about the product with someone else. But once you make it known that you have a product, an invention, and it's publicized, it's no longer in the public domain and you can't patent it. So one has to be very, very careful who you tell and make sure you have a non-disclosure agreement. There are three types of patents. There's the utility patent, a design patent, and a plant patent. The utility patent is the one most of us think about when we talk about a patent. It's a patent for a machine, an article of manufacture, some device, some invention. A design patent is different, where we're talking about a design, an ornamental concept. So it's not, you're not patenting a device. And then plants can be patented for asexually reproduced plants. So we have here the three types of patents. The utility patent is the most common one, the plant patent, and then the design patent. By the way, if I have a design patent, it could be that I could have two patents. One is a utility patent and the design on the ornamental aspect of that invention. Now, the utility patent is going to be good for about 20 years. 20 years, that's it. Design patent is good for 14 years. And then the plant patent is also good for 20 years. So looky here, we've got the utility patent, which is available for 20 years. You're seeing some drugs coming off their patents, and those become generic. Okay, those become generic, and companies then, generic companies can go ahead and manufacture those drugs. So, you know, if you have only 20 years, sometimes you might want to think twice about patenting something. We'll talk about that in a moment. Why would you patent something? Well, one is prestige, ego. I did it. I was the first person to come up with it. Another idea, another reason to perhaps patent something is to go ahead and to enable you to license it. Hey, I don't want to manufacture this, but I want to give someone else permission and I'll get some money. So if I give them a license, that's another way of making some money. Protection against imitators, that's a possibility. If we've spent a great deal of money on research and development, maybe I want to recoup that money, and possibly I can go ahead and recoup that money using from the patent and licensing it. If I patent something, I may have an advantage over my competition. So I could sue my competition if I think they are infringing on my patent. Okay, so and sometimes I can trade one patent for another patent, or the ability to do something with another company. So there are a whole host of reasons why I might want to patent something. If I do patent something, it's got to be useful. Okay, the patent authorities are going to go ahead. The US government is going to ask you, is this useful or functional? Now, this is qualitative, you know? It's something that's useful for you may not be useful for someone else. Is it novel? Oh my goodness. Is it different from anything known before? Is it different from past work that's been done? Here again, this is not 100% clear. This is a little bit of qualitative and non-obvious. Is this idea that you've come up with not obvious? Is it an improvement that would not have been obvious to workers of average skill in that technology? Some of these questions are uncertain. And that's why there could be a question about whether this is something is patentable or not. So what cannot you not patent? Well, you can't patent the mathematical approach to something. You can't patent a theory, a law of nature, computer programs. You saw before that we could maybe copyright some computer programs, but we can't patent them. Medical and surgical treatments, a business method, and parts of the body, you can't patent. And aesthetic creation, well, maybe I can come up with a design patent, you know, perhaps, but it's not going to be a utility patent. Question is there any reason not to patent an invention? Well, a moment ago, I said that if the information goes out into the public domain, it's no longer patentable. No longer patentable if it's in the public domain. Is there a reason not to patent something? Well, you know, Coca-Cola never, ever patented their information. You don't know what's in the secret recipe for Coca-Cola. That's in somebody's safe down in Georgia, I believe it is. So they never want to do it. And why? Because remember I said a patent is good for 20 years. And Coca-Cola has been around for more than 20 years. So if they had patented the secret recipe for Coca-Cola, then other people would know what it is today and they could manufacture Coca-Cola. By not patenting it, they've kept it as a secret. And the public doesn't know what the content of Coca-Cola is. And then finally, there is a reason why I might not want to patent something, because of money. I'll show you in a moment or two. It's expensive. It's very expensive to patent something. So, okay, these are three reasons why you may want to think twice about patenting something. So what is the patent? It's a grant by the United States that prevents other people from making, using, selling your product. Okay. And the patent that you get in the United States is only good for the United States. It's not good for anywhere else. As I said a moment ago, a patent doesn't necessarily give you the right to make that product, because it might be part of that product might be patented by someone else. So one has to be careful. Finally, you have to understand this. The United States government doesn't enforce the patent. So if I make something, I patent it and I manufacture it in New England, and somebody from Arizona takes the same product and they manufacture it in Arizona and sell it out west, if I don't know about it, that person can sell that product out west. The US government is not going to stop them. It's up to me as the owner of the patent to find out that this person out west is making this product, and I have to go after them. I have to go and sue them. The US government is not going to do it. So the owner of the patent has to protect the patent. Okay. As I mentioned earlier, and just because I have a patent, on something doesn't mean I can manufacture it. Here's the situation with the pencil. If I have a person with the pencil having a patent on the pencil and a person having a patent on the eraser, the combination can't be manufactured by either one of them. There has to be an agreement between the two in order to manufacture the combination. So if, on the other hand, I infringe on somebody else's patent and they catch me, think they gotta catch you, then all of our product will be removed from the market and the product would be destroyed. I would have to pay damages to the patent owner. I see somebody has asked a question. I'll come back and I'll try to answer the question. Might be a fine if I take that patent, that person who infringes on my patent. If I infringe on the patent, I can be given a fine and I could be sentenced to prison. Right now, the patent law is not based on a first to invent. Even if I'm the first person to invent something, it doesn't matter. I have to be the first to file. So I have to file first in order to get credit for that invention. Here are the parts to a patent. I have an abstract, a little background of the invention. I need some figures. I need a detailed description or specification. And then I need the claims. What am I really patenting? Now, I must tell you that this is kind of difficult to do. And this is a full-up patent. And usually something like this is done with the aid of an attorney. But there is something that you can do if you're so inclined. You can create something called a provisional patent. A provisional patent can be done by an individual. You can do it very frequently without an attorney. Recognize that this patent, this provisional patent, I can file it, doesn't cost all that much. It's good for 1 year. So I have protection for 1 year. And during that year, I have to go ahead and complete a full-up patent. Okay, so I have to create a full-up patent. So the provisional patent does not necessarily have to include all of the patent claims. That will go into the full-up patent, but I would recommend that you put as much of these in the provisional patent as you possibly can. Define your product. How is it structured? How do the parts connect? How do the parts interact? Question is, why is your invention unique? Why is it different from everything else? Why is it different from what lawyers call prior art? And so you have to put that down and make it abundantly clear to the patent examiner in Washington why you're special, why you're so different. That has to be abundantly clear. That has to go into the claims. Doesn't have to go into the provisional patent, but it will have to go into the regular patent. So the provisional patent requires a specification. It will need drawings. There's some money. And then there's a cover sheet. And the actual provisional patent looks something like this. And you can go to this website, US government website, and you can download this form. I'm not asking you to read this form, just there's a provisional utility patent application. You download it and you begin to fill it out. And that's something that you can do yourself. If you have claims, I suggest you put it in. You don't have to, but I would suggest it. As far as the specification, which is part of the provisional patent, as well as the regular patent, this is what we need. A background, what's the prior art? What preceded this? What's your invention all about? Your drawings, okay? You'll need a little description or an explanation of your invention, how it works. Okay, so all of this has to go in. If possible, identify your claims. Okay, because while it's not needed for the provisional, it will help you clearly identify why your system or why your invention is unique. All right. And then you'll need an abstract, a brief summary of the entire spec. So I raised the point earlier about the fact that when I patent something, it's only in the United States. If I patent something in Washington, it's good for Washington. There is such a thing as a patent cooperation treaty. That's not an international patent. There ain't no such animal as an international patent. But I can begin to file for patents across the world. And the way you do that is you have this, and by the way, these are the countries, all the countries in blue over here are part of the Patent Cooperation Treaty. So if I want to file a patent in all of these countries around the world, one of the things I have to do is I have to file a form, and that form is going to go to Switzerland. So I'm going to file my form. It's going to go to the United States, and it's going to go to Switzerland right over here. That's the World Intellectual Property Organization. And by the way, I really recommend you bring a lot of money because you're going to have filing fees in all the countries that you want to file in. So you come up with your invention, You file perhaps in the United States, and then you file in Switzerland. And then they will in turn file in the different countries around the world. Now, notice how long this is going to take. It may take as long as 30 months, 2.5 years, for them to file across the world. So you'll discover that things go slow in the patent world, but you can file internationally. Every one of these countries will charge you some filing fees. So a way to handle patents is, one, go ahead and do a provisional patent application. That's the one I do by myself. And then, or I do a non-provisional. Okay, if I do the provisional application and then I do a non-provisional, I have 1 year when I start this provisional application to file the full application. At the same time, I can start filing for that patent cooperation treaty if you want to file across the country, across the world. So that's a possibility. So start with a provisional and then go to a non-provisional, and I can also file with the patent cooperation treaty. But remember, every country requires a filing fee. Can I patent software? Well, yes and no. Not all types of patents, software is patentable. Economic theories, ways of doing business, mathematical methods, computer programs, these are not patentable. But any software that you develop has to meet the patent requirements. It has to be new, has to be useful, non-obvious. And there are about 16,000 software patents filed every year. So a possible patent in software relates to computer-aided design software, insurance and financial software systems, operating systems, e-commerce solutions, compilers. So I strongly recommend when you go beyond the provisional patent that you work with a patent attorney. And you want to give as much information to the patent attorney because they charge a lot of money, as you will see in a moment. They charge a fair amount of money, and you want to tell that patent attorney as much as you know about the state of the art. Why is your invention different from the previous inventions in this area? So you want to make sure that you do some research and help the patent attorney. If you leave everything up to the patent attorney, they're going to be charging $400 or $500 an hour, and they're do some work that maybe you should have done. Okay, you're going to have to tell the patent attorney what are the key structural features about your patent, about your idea. Now, just so you understand, I'm going to give you a couple of slides on this. It's going to take you somewhere between 3 years and 6 years to go ahead and patent something. The first time you submit something, it's going to take maybe from 6 to 12 months. You'll get your provisional patent application in about 3 months. If a lawyer does it, it might cost you as much as $10,000. And then you want to have your international patent. That's very expensive. Remember, it costs money to file all of these things. So it'll take a long time. In terms of cost, a very simple invention will cost you between $5,000 and $7,000. A more complicated system, like an MRI machine or a telecommunication system, will cost you between $15,000 and $50,000 for lawyers' fees and filing fees. It's not inexpensive. So the process is, what type of intellectual property protection do you need? Is your invention patentable? What kind of patent are you going to use? Design patent, utility patent, provisional patent, and then you're going to submit your application. Your examiner is going to review it once you submit it to Washington, and your examiner, chances are, will send it back to you. They'll want to have some changes made. You'll send it back to them. Ultimately, if you're lucky, you get your approval, and then you have to maintain your patent by looking out for people who are trying to copy it, because the government doesn't do that. So here's a chart. You can see that as of last August, there were about 600,000 unexamined patent applications waiting to be reviewed. Okay, it takes about 16 months for the first review in Washington. It'll take 23 months, 2 years, for a complete review. That's how long it actually takes. So it's going to take you 2 to 5 years to get the whole thing through. And you have to go through this process. And you can see here that your patent is going to be reviewed. You may have to file an appeal if they don't like something. There are going to be fees. And there's maintenance fees later on once it's patented. Remember, I told you that one of the things you should be doing is going online and doing as much research as possible to see what has happened before, so that you can save some money. And you can do some searches at the patent office. There are 2 patent website-based databases. One is the US Patent Office, another one is the Google office. So I'm going to show you how I can use that. I used to have a lot of hair. For those of you who can see, I know I'm kind of bald right now. And while I was losing my hair, the hair would go down the shower drain. So let's make up, I want to come up with a patent or an idea for a hair removal device that will go into a shower drain. this is my idea for a patent. I want a hair removal. I can put something into a shower drain that will catch the hair. So I'm going to go to the patent office, like you see here. I'm going to go to the patent office. Here's the patent office right over here. And I'm going to do a search. When I do a click on quick search, I'm going to go to this screen. And you can see over here under term 1, I put in shower. Term 2, I put in hair. And I do a search. And when I do a search, I get these patents that are coming up. And you can see the first one says sink and shower drain hair collector. So let me see what my competition has done. I'm going to take a look at them. I'll click on that. And here it's coming up. A company in Glen Cove, Long Island, Duke Innovations has come up with a patent. They did it in 2016. And they have a patent right over here. So I want to take a look at the patent. Here is the patent from this company. I click on that and I review this, and I want to compare this versus my idea. And by the way, do you see that this is a design patent? Design patent. It's not a utility patent. So they are doing a design on this. They're taking a look at the design. Now, this is difficult stuff. And there's a way you can get some free help by going to UConn. They have an intellectual property and entrepreneurship law clinic. And they can help you. You can contact them. And they can help you with perhaps a provisional patent. But my question to you is, after all this, you really want to patent it. It's going to cost you a lot of money. It's going to take a lot of time. And then you're going to have to monitor this patent yourself to make sure that no one else copies it around the country or the world, for that matter. So that's a question that you have to ask. On that note, I'm going to stop and maybe answer some questions that you might have.
That would be great. Thanks, Harvey. There are a lot of valuable information there, a lot of great experience and insights, and I'm sure we have lots of questions from our attendees. And what we'll do now is we'll use the remainder of the time and take as many of those as we can up to the top of the hour. And just a reminder, if you would like to ask a question, please use the Q&A button at the bottom of the screen. And we'll take as many as we can. So we have a few already, and I will just start. We have a question here from Jack. When it comes to intellectual property re-advertising design, if a client were to use your design concepts without compensation, what are your recourses?
Well, if you have copyrighted it officially, you may have resort, you can sue. If, on the other hand, you have not, if you're trying to patent something and you haven't filed a provisional patent, in truth, you have none. You have no resources. If it's not copyrighted and it's not patented, or you don't have a provisional patent, you're in trouble. You don't have any resource.
Okay. Just while we're waiting, Harvey, could you maybe flip back to the slide with the Yukon reference so that people have time to see that? That's great. We have another question here from Jeff. Most drawings in patent applications seem to be handcraft drawings, not CAD drawings. And why is that?
Well, if it's an older one, that's one of the reasons. Anything done today is, generally speaking, done by computer-aided design, but certainly an older one would not. If it's a provisional and a person doesn't have CAD capability, that's okay. They can do it by hand. That's fine.
Okay. We have another question here from an attendee that says, I'm facing a huge copyrights management enforcement challenge. Does Dr. Hoffman know of any success stories with copyright management enforcement? And if so, what did they involve, such as a law firm and or a business that provides copyright management enforcement?
Okay, keep in mind, I am not a lawyer. I said that at the outset. I'm not a lawyer. I don't pretend to be one. And if you need legal guidance with respect to either patent information or copyright information, you have to find the appropriate people. I do know that the cost for an individual to file a patent is very high, and people have not been, individuals are not in general going to go ahead through and spend all that money to protect a patent. As far as a copyright is concerned, if my memory serves me correctly, you can copyright something, and if somebody infringes on your copyright, I think there's a maximum of $75,000. But I'm not absolutely certain of the maximum amount that you can obtain.
Okay. Very helpful. Here's one, another one here. Can we use the ideas to make something from an expired utility patent?
Yeah, sure. You can go ahead and use an expired utility patent. You can't repatent it. You can build on some ideas. Keep in mind that in order to patent something, it has to be novel. It has to be different from prior art. So if all you're doing is reformatting an existing or an old patent, you can question whether the people in Washington are going to permit you to go ahead and do it. And then remember, it costs money. So I don't know if that's answering your question or not, but it's got to be novel. It's got to be different. It's got to be unique. It's got to be different from prior art.
Okay. Here's a question from Dan. You didn't talk at all about trade secrets. Do you have any comments or observations on trade secrets?
Well, you're right. You're right. I mentioned about Coca-Cola. Trade secrets, you keep the invention locked up in a safe, or you keep the recipe locked up in a safe. You don't tell anybody about it. And that's the only thing you really can do. It's called buying a good safe and putting away that recipe. A trademark is something different, but trade secrets, hey, don't tell anybody.
Okay, seems like a good strategy. Actually, the next question is on trademarks. Do you have any advice on trademarks?
You can patent it, not patent. You can register a trademark. A trademark, and one of the first slides I had showed you some different trademarks. The shape of the Coca-Cola bottle, the letters of Coca-Cola, when you spell out in that fancy script, those are all trademarks. The golden arches from McDonald's are trademarks. The symbol, the Mercedes symbol, all of these are trademarks, and you can infringe on that. And yes, you can keep renewing that all the time.
Here's a question from Richard, which I think you touched on during your presentation, but maybe you can just comment briefly. It's how to determine if an existing product on the market is already patented.
Generally, it says so, or it says patent pending. The patent pending is typically, you remember, I indicated to you that it takes anywhere from 2 to 5 or 6 years to get a patent approved. During that time, even though it says patent pending, you can go ahead and copy it because no one knows with certainty that that invention is going to be patented. However, if it is patented, then you're in big trouble because then anything that you manufactured will be pulled out and you can be sued. So it should say something about patent pending or something of that nature on the system, on the device.
Okay. Here's one from Carrie. I've heard that a software app can be patented if it is embodied in a physical device. How would that work? I've designed / invented a method for medical diagnosis.
I am going to sidestep this question. In general, software, and I indicated there are times when software can be patented, but it doesn't matter if it's embedded in the system. The idea, the system or the invention, you really have to discuss whether you're going to patent the software or patent the invention, or maybe a combination of the two, and that has to be done with an experienced patent attorney, which I'm not.
Yeah. Understood. We have one here from Michael. I published a paper in December of 2020 that described a method that might save some lives. It is complicated and may not be worth pursuing it. I wanted to submit a provisional application in the next few days. Can I just cite the paper as sufficient information?
Once it's out in the public, it's no longer patentable. So the fact that you published it, it's gone. The idea is it's over.
Okay. And one last one. I created a curriculum years ago for a US government agency using public domain data / research. I'm seeking to completely redo it for use today in my company. Is copyright or trademark the approach to take?
Well, I don't think a trademark, I'm giving you an opinion here. So remember that from a non-legal person, it would seem that copyright is more appropriate than a trademark. A trademark is a symbol of something. So like, from what I'm hearing is this is a curriculum, it's a set of instructions, and that's, I think, copyrightable as opposed to something that is appearance, that's an appearance, a trademark that looks like a Coca-Cola symbol, Coca-Cola bottle. That's an appearance of something. So I think it's more copyrightable.
Okay, that's great. Well, unfortunately, that's all the time we have questions for today. If I could ask you to move to the last slide, please, Harvey. Just as a reminder, this webinar was recorded and the materials will be available on our website in the next day or two under fairfieldcounty.score.org. Our next live webinar is on Friday, December 17th at noon, and the topic is aligning purpose with Profit with Emily Reasoner presenting. And again, you can find more specifics on our website. If you'd like to take advantage of free individual counseling, you can use the yellow bit.ly link on the screen, or you can go to our website and click on Request a Mentor. And if I could also kindly ask you to fill out your evaluations that'll be sent after the webinar, they're very helpful to us. So again, on behalf of SCORE, I'd like to thank you all for attending our live webinar today. And in closing, a special big thank you to Harvey Hoffman for presenting. And stay well, everyone, and enjoy the rest of your day. Thank you.
Okay.